Thank you. It's nothing like talking about government contracting after lunch. So wake you up one way or the other. Talking about false claims, I wanted to set the framework because a lot of people are understanding, hey, False Claims Act, that must be just in regard to billing mistakes, but there's usually an underlying issue that's not just about billing. It could also be about the Procurement Integrity Act, which a lot of companies, when they're hiring government officials or they're working with government contracting officers in negotiating bids, they fail to appreciate. They think that it's just another commercial deal. I'm going to handle it like a commercial deal because the government's just another customer of mine. Unfortunately, or fortunately, that's not always the case, especially because of what a government contracting officer is restricted to do and the information that is shared going both ways. So unlike a commercial transaction where you might want to hold back a little bit to make sure that you have an advantage during the negotiation process, the government, because it's the sovereign, always requires that you go above and beyond the extra mile. And that's also where you get into the Truth in Negotiation Act. The Truth in Negotiation Act says that you won't lie to the government when you're bidding on contracts, that you're going to be upfront and give the information that is requested of you, something that you would never ever consider in a commercial transaction. Now, this crosses all industry boundaries. A lot of folks possibly in this room think that this does not apply to me because I don't directly do business with the government. I might be a real estate company, I might be a healthcare provider, and I deal with other types of areas, but not directly with the government. But as government contracting, of course, the federal government is the #1 contractor in the world, providing a lot of money to all different industries. It slowly has seeped into, the tentacles of government contracting has seeped into every industry. So when you're doing due diligence, you're doing compliance on the mergers and acquisitions, and you're doing other types of transactions, you have to keep in the back of your mind, does this involve any type of interactions with the government? And if it does, have we complied with all of the rules? That's where we get into the Federal False Claims Act. Now, there are many states that have what we call mini False Claims Act that you also have to be cognizant of. That's the situation where the state attorney generals will collectively get together and bring a False Claims Act while there's a parallel federal investigation or litigation that's ongoing. And you have to keep that in mind as you're doing that negotiation with the federal government agencies, because it could be just as easily that they're either sharing information with that attorney generals, or the attorney generals are going to come in and ask for the exact same information, basically like a coattails action. That's even beyond all the shareholder derivative action suits, class actions that would follow on those coattails. So you have to be cognizant of the different laws that are applicable. And the False Claims Act is knowingly submitting or causing others to submit false claims to the government for payment. It applies for services not rendered, falsification of time, and efforts reports for reimbursement. Now, what we've run into over and over again in these last few years is because the contracting officers are now trained on the False Claims Act. And immediately upon a contract dispute coming on, the first thing that they drop is, well, this is a false claims matter, we're going to refer to the OIG. So something that would have been resolved several years ago, such as a time card reporting, a product being defective, a product for the pharmaceutical world that does not meet the criteria of what has been disclosed to the FDA. Those are all situations that have turned into False Claims Act cases quite quickly. Now, as a little bit more of a background, we wanted to go over the DOJ guidance that has come out. And in your materials, I include an article. I don't think it's new guidance. This guidance has existed for at least the last 15 years. It's just being updated over and over and over again. But in February 8, 2017, the DOJ fraud section did issue its guidance, and it does give a good framework for you in-house counsel as to maybe a compliance checklist. But in reality, they say do not consider it a checklist because they look at each investigation under totality situation. So there are definitely factors that you have to consider, but these factors have been around for a long period of time. But one thing the guidance did say is that they're going to increase multilateral investigations. with both foreign governments and state governments. So that's not going to go away. However, there is a thought process out there that as the federal government stops cooperating with foreign governments and stops cooperating with state governments on different areas, then does the enforcement mechanism also get decreased? So keep your eye out for that in the future as to whether or not this multilateral cooperation will continue. However, they did say that there is going to be increased investigations as to FCA and corruption type activities. This will also mean, possibly because of the guidance, of more voluntary disclosures. The company finds out about something. And when you're doing voluntary disclosures, you want to look at the corporate guidance as the roadmap of going forward of how you're going to be doing that voluntary disclosure. It should not just be a data drop on the government. You have to be thinking of the end game, which is trial. That voluntary disclosure will be used against you at trial. So you have to frame it into a concise way of, our goal is to settle with the government. Our goal is not to go to trial with the government if you're making a voluntary disclosure. So try to serve it up on a silver platter, but obviously tell the story from your perspective. So the corporate charging guidelines provides 10 Philip factors. Many of you are aware of this as to whether or not to pursue an investigation. One of the main issues, which surprisingly in this day and age, are the lack of pre-existing compliance programs out there, or the ones that sit on a shelf and gather dust, the ones that are not audited every few years, the ones that are only taken down when the Department of Justice or an OIG send a civil investigative demand. So from that perspective, you do want to make annual reviews of your compliance programs to ensure that there's any updates. What cases have come down? What other factors should we be considering? The other thing is in regard to remedial efforts to implement a compliance program once an issue has been determined. If there's an issue that has been determined and the company takes efforts to mitigate it, it's a thing that you want to consider. So the compliance guide that was issued in 2017 is broken up into 11 sections. As I mentioned, it is not just a checklist. So just because you think you've met all 11 factors, if you don't meet one of the factors in a way that the government deems appropriate, it's still potential liability. Here are the 11 sections. I won't go through every single one of them, but one that is of significant concern to the government, especially when you have a large client customer, is number 2, the senior and middle management. What is their commitment to compliance? Is it all about cutting, saving the bottom line? And compliance usually is not considered a money generator. It could be best practices, ensuring streamline, ensuring the proper chain of command, people doing their job. Those are all effective ways that businesses have used compliance programs to enhance business opportunities. But a lot of companies don't appreciate that in that context. But the senior and middle management commitment to the compliance program is a significant issue that the government looks at. How is the messaging getting down to its employees to not defraud the government? This also goes across the lines in any dealings with the government. I bring up the the FCPA, which deals with bribery, anti-corruption, the Federal Corruption Practices Act, which has been going on since 1977, was from Watergate. Basically, after Watergate, it came out that a lot of corporations were bribing U.S. officials. Shocking. And what they did is that they sent a survey out to the rest of to those same companies saying, well, if you're doing this here, and it was legal at the time, if you're doing this here, what are you doing in foreign countries? And what those companies reported back is, yes, we do pay bribes to obtain government contracts abroad. And they had to basically meet their competitive advantage. So the government, Congress passed the FCPA, and it's gone through maybe some dormant stages, but it has been basically the issue that the government has been most concerned about from an international trade perspective. And everything with the FCPA trickles over to the FCA. Okay? So you have the fraud guidance and you have the FCPA guidance. But if you really look at them, they're talking about the same factors. So one thing that the FCPA it's a pilot program in regard to voluntary disclosures and how to put together a compliance program. That should trickle across all the different areas that you're trying to comply with. This administration has reiterated its dedication to the FCPA and to root out corruption at every level. Now, one of the things for both the False Claims Act and the FCPA, it's quite lucrative. The fines and penalties on companies are large. They make good headlines. And taxpayers never object to a $1.5 billion fine on a large German company. So one other activity is the Yates Memo. I'm sure many of you are familiar with the Yates Memo. I'm surprised it hasn't been renamed yet. I'm sure that is on the to-do list. But Sally Yates was the Deputy Attorney General who targeted individuals, saying that there's going to be a shift from corporate liability. The corporations can just write a check. We're going to go after individuals first. Now, this has been now reiterated both in the fraud civil division's guidance as well as in the FCPA pilot program. So again, nothing's new. These are the quotes from both Attorney General Sessions and Acting Deputy Assistant General Trevor McFadden, reiterating the importance of going after individuals. And if you notice that there's a connection between the Philip factors, which is the number 2 item that I referenced previously, which is about individual accountability and senior management commitment to compliance. These are regulations that I wanted to reference because it's not just in the guidance from the Department of Justice that we get our requirements. If you are doing government contracting, you're having involvement with the government, there are going to be guidelines and there are going to be regulations that need to be followed. These are a few that are inside your contracts. So it's not just the law, it's actually a contractual violation if you violate one of the ethical requirements. But I wanted to also talk about the False Claims Act, some trends that we're seeing. So the case, as I mentioned in the beginning of the presentation, the typical trend of a contracting officer is to immediately say upon a contract dispute, this is a false claim. But the courts have been pushing back on that. And in recent years, we have now had a more defined elements of what an FCA action can be. And then started in 2016 with the Escobar case. And the Escobar case basically gives a roadmap if you're trying to defend against an FCA action. So one thing as defense counsel, we always look at internally. When did our company employees know it? What did they know? And whether or not it was material. Well, what Escobar tells us is also to look at what the government knew and when did they know it and whether or not it's material. And as you're having those discussions with the U.S. Attorney's Office or OIG in regard to whether or not a False Claims Act action has actually occurred, the analysis should not just be on what the contractor did, but what did the government do? Was the government silent in different areas that they should have been giving notices? This is most notably in Medicaid and Medicare, those rules and regulations. Or were they complicit in the activity? So these are situations that you have to be able to know whether or not to challenge the government's position rather than just defending your own. That's definitely on targeting what's called the scienter element, which is the knowledge element. Now, what the courts have also said is if the government has full understanding, or they should have known, same knowledge that's applicable to the defendant, should have known that something was occurring, then there can't be a false claim. False claim has to be false, but if the government knows about it, it's not false. Which gets us into the Berg case from Alaska in 2016. So if you're dealing with the government, I can guarantee you one thing, it's complex. And this court recognized that it was complex. Government contracting inherently with all its rules and regulations and compliance is complex. And what Honeywell did here was it provided everything to the government. So it had to certify its pricing data. They not only certified it, they provided all the pricing data. The government had everything Honeywell had. And what the district court said is there's no way that Honeywell could have materially misled the government about the contract because the government had all the same information. So it's a double-edged sword. The government wants the information, so give it. And not treat it as a commercial transaction where you're trying to reserve some of those benefits. These are some other activities that we've learned from Berg about agenda, notes, communication, and keeping track of correspondence with the government. That becomes an overly big burden, but it's a requirement now for basically if you want to maintain compliance with government contracting. So some best practices, as you can imagine, my first bullet. Senior management commitment, early and often. Sending out the emails to employees about the importance of following company policies and, of course, the law. Providing essential training to the employees that are responsible. These are all factors of trying to avoid the litigation before it actually happens. And then when you know the litigation is going to occur because you've received that CID demand, you go look at these factors to determine whether or not they've been met because you're now building the case to the government before they've actually filed a lawsuit. One thing that was reiterated, and it's the last bullet point here that I want to make sure you all appreciate, are the Upjohn warnings. So when you're going in for an investigation, making sure that the employee fully understands that you are the company's lawyer, you're not the lawyer for the employee, and actually memorializing that either internally or actually having the employee sign it is very important for ensuring that the privilege is not waived. There's been several cases recently about the privilege, and we all, of course, want to make sure it gets maintained. So the takeaway from this presentation is that if you've decided to enter into the government contracting realm, or you're doing business in any way with the government, it's not like a commercial transaction, and you have to prepare accordingly. Thank you for your time today.